Your Honor, it's late, it's Friday, and I'll be brief. I admire Mr. Kemp's ability to take what he has and turn it into what he wants. Thank you, Your Honor. Jim Neale on behalf of United Natural Foods West. John, can you pull up let's start, please, with the plaintiff's motion on that itself. Judge, the plaintiff gets to decide what causes of action to advance. And in their...
And I do realize there's negligence per se, negligence, strict products liability, and so on.
And punitive damages, I guess. And so, obviously, the second amended complaint, as the plaintiffs admit on page 4 of their motion in limine, renders all of the standard of care evidence, the conduct of the parties, relevant. The argument in this case is that UNFW should be subject to punitive damages because it did not audit real water. The argument in this case is that UNFW was negligent because it did not audit real water. And let me be very clear about what we're arguing. We are not arguing that we're exempt from food safety laws or that we have no responsibility or that we're not here to indemnify Whole Foods. None of that is the case. We have to do everything we can possibly do between the time we receive a product and deliver a product to ensure its food safety. Now, the plaintiff has an expert, Dr. Hutt, an industry standard of care expert. I've heard everything the court has said about the Trujillo case, the Ford Motor Company case, and strict liability. There would be no place at all for Dr. Hutt if this were just a strict liability case. As the court has repeatedly informed us, the conduct of the parties would be irrelevant. Strict liability is strict liability. Page 4, please, John. But what the plaintiffs have done is they have injected a negligence count. John, there's a sentence that says such evidence is only relevant in a negligence action. And I don't see it there. I may have
it was just up there.
I'm sorry. Thank you. John had it and I didn't.
Such evidence is only relevant. That's the third line.
Third line down, Your Honor. This is the plaintiff's motion, saying that the evidence they're trying to exclude would be relevant if this were a negligence action. This is a negligence action. They've completely lost sight of what the grounds they moved on, and that's why Mr. Pepperman has made up an argument on the fly and citing cases that aren't in any of the papers, not in the original motion, not in the opposition, not in the reply. This is a negligence action. It's a negligence per se action. It's a punitive damages action. Our compliance with the applicable standard of care is certainly relevant. It's not dispositive, Your Honor. I don't mean to have ever given the court the impression that because we satisfied our federal regulatory obligations, we're entitled to judgment as a matter of law. But as the plaintiff's expert herself recognizes, that standard of care helps determine, that regulation helps determine the standard of care. So because, and what I point out, Your Honor, is the plaintiff's position is we get to tell the jury about the defendant's failure to adhere to regulatory standards, whether that's the definition of adulterated food or HACCP regulation or something else. But you defendants don't get to do the converse and inform the jury of your compliance with either the same or other applicable regulations and laws. Heads I win and tails you lose. That's not the law. It's not the law in any case, certainly not in a negligence case. So while it doesn't immunize United Natural Foods, it's certainly relevant to help the jury determine the standard of care. We are a warehouse, Your Honor, and we are truck drivers. And we get sealed product, and we hold sealed product, and we move sealed product. And the federal law treats warehouses, distributors of packaged unexposed food differently than it does everybody else. John, can you pull up the well, let's do this. Let's go to the regulations. Let's go to the Heidel clip first, please. The warehouse exemption clip. This is not our expert, Your Honor. This is Milwaukee's expert, a food safety expert that Mr. Kemp deposed. And Mr. Kemp has highlighted to the court several times because he very much likes Mr. Heidel's opinions because they're critical of real water. And then when we asked Mr. Heidel about the warehouse exemption, this is how he explains it. Starting at page 82, line 9, John.
Well, I'm just interested, you know a lot about Part 117 and the preventive controls. And
yes.
one of those parts is supplier verification, correct?
That's correct.
And you're probably familiar with the, I'll call it the warehouse exemption in 117.7.
I am.
And tell me if I'm right or not, but that specifically exempts distributors who deal only with sealed products from supplier verification activities.
That is correct. Oh,
And
sorry.
one of those supplier verification activities is in-person audits. It's not the only one, but it's one of them under 405.
Same objections. And Mr. Heidel, just to explain it, I have to make my objections to protect the record. So go ahead and answer Jim's questions.
I certainly understand that. May I ask you a question, Jim?
Yes, sir. Of course.
In the handling of the real water product, it came into, let's say, UNFI's warehouse. Did they repackage it in any respect, or they just stored it and moved it out to a retailer?
Yeah, never repackaged, never relabeled, never reformulated, sealed containers the entire time.
That's correct. And your statement is correct.
No audit, no supplier verification requirement, warehouse
Right.
exemption under FSMA.
Exactly.
And that's consistent with your decades of experience in bottled water, sir.
It is.
Your Honor, this is the converse of what Dr. Hutt, the plaintiff's expert, is saying. She's saying that there's a standard in the industry that everybody should audit all of their suppliers, and that's been her experience. Dr. Heidel, Dr. Atchison, others in the industry have very different experiences, and the jury's going to have to decide in order to determine the negligence count or the negligence per se count or the punitive damages, whether UNFW conformed to the industry standard of care. See the court looking at the regulations. Would it be helpful to walk through those?
Well, I see it now, and I guess my law clerk pulled 1.117.7, but I need subpart C, D, and G to kind of understand the interplay and how this all works.
Let me suggest how they fit together, Your Honor, and then we're happy to provide it. I'm not sure that C and D necessarily apply to this situation, but I do agree you need G. So if we could pull up, John, 21 CFR 117 to start. Actually, let's do this first. Go to the Hutt opinion. This is the plaintiff's expert, Your Honor. Let's start where the problem starts, and that's Dr. Hutt's misunderstanding of the applicable laws. Can you go all the way to the bottom of that, John? The very, well, it's going to be the footnote on the bottom of page 19. All right. Dr. Hutt, Your Honor, the plaintiff's food safety expert, relied on the Food Safety Modernization Act. This is the last entry. Final rule for the preventive controls of human food. All right, that is part 117. All right. She opines, John, if you could go up, please, to page let's go to page 3 of 36, please, John. There's a paragraph right above the professional background heading, if you could call that out. Just above that, John, I'm sorry. Thank you. Dr. Hutt has opinions about real water and how it was deficient. And then she transitions and says, UNFI, as the customer of real water, should have audited its supplier. And that comes from the hazard analysis and risk-based preventive control rule in the Food Safety Modernization Act that she just cited below. So if we go to that, John, 21 CFR 117, please. This is that hazard analysis, risk-based preventive controls for human food. And what this does, Judge, is it obligates anybody who processes, packages, or holds food to do certain things. They have to look at the biological, chemical, allergen hazards that their product might pose. And they have to assess that risk, and then they have to impose preventive controls. That makes sense so far, Your Honor?
Oh, no, come on.
Okay. And then if we go, John, please, to 117, and maybe can you do the table of contents for that page, John, if you could click on that?
As far as part 117, how long is that?
It's long, Your Honor. It's very long.
55 pages.
It's long. Can you just hit part 117 there, John, just to give the court? I think that's good.
Go back to the first page, could you, for a second?
Well,
I think the starting page, because I want the whole act.
Yeah, let's go to 21 John CFR 117, please. There you go. Perfect.
And kind of go down, John. No, I'm sorry, up. Okay. Then this is Title 21.
Title 21.
Chapter 1, Subpart B, Part 117.
Yes, sir. The site would be 21 CFR 117.
Okay. And you can go to your thing. All right, go ahead, sir.
Thank you, Your Honor. And what that requires, again, is a whole host of preventive controls for people in the industry. And if we go down, John, please, if you scroll down, it's broken into 7, I believe, or 6 subparts. The last of which is subpart G. And subpart G is the supply chain program. That's the part that Dr. Hutt, there's no suggestion that UNFW did anything wrong from the time it received the product until it distributed, or that it caused the alleged defect, or that there was shortcoming in its food safety programs in its warehouse. The only allegation is that it should have done something prior to the receipt to audit real water, to discover the problem before it arrived in its warehouse. So subpart G is the requirements that the Food, Drug, and Cosmetic Act imposes on food producers and distributors and retailers to vet their supply chain. Make sense so far, Your Honor?
I'm following you right now.
All right. And you can see that 405, all of these are part of subpart G. 405 makes you have a program. 410 talks about what the requirements of the program are, on down the line. You have to use approved suppliers. And then there's even a section on on-site audits. That's 435. If we go, John, please, to, can you click on 117.410, general requirements? And if we scroll down, it tells you what your supplier program must include. And then if we get to B, it must include using approved suppliers, determining what the appropriate supplier verification activities might be, documenting those activities, and then imposing a control where required. And then subsection B there, Your Honor, talks about what are the different appropriate supplier verification activities. And this is left to the discretion of the facility. They can, depending on the risk that they perceive, they can go do an on-site audit. They can test the product in question. They can review the supplier's records. Or they can do other appropriate supplier verification activities. There's no prescribed list. Audits are one possibility. Here's the critical part, though, Your Honor. And this is where Dr. Hutt and Mr. Heidel and UNFW have a dramatic difference. Dr. Hutt says everybody has to do on-site audits every year, period, full stop, no exception. She's just plain wrong, Your Honor. She doesn't know the regulations of the industry. Mr. Heidel's already explained that. And if we go to 21 CFR 117.7, the exemption, and John, I think the easiest way to get there would be go back up to the top, perfect. And go to 117, please. Thank you. And go to 117.7. The FDA, Your Honor, and federal law, and the Food, Drug, and Cosmetic Act, and the industry, as Mr. Heidel explained, treat warehouses differently. They are a pass-through conduit. Now, that doesn't mean they're absolved of liability. We bought the product. We sold the product. We're in the chain of distribution. If there is a defect in the product, we can be held strictly liable for it if it causes an injury. But, Your Honor, in terms of negligence and punitive damages and negligence per se, our conduct and whether we adhered or did not adhere to the applicable industry standard of care are relevant. And 117.7 says if you're a warehouse and all you're doing is taking sealed boxes of sealed bottles and putting them on a shelf and then shipping them out, you do not have to do anything in subpart G. You don't have to go do an on-site audit. You don't have to go check the paperwork. You don't have to go do anything. Now, again, we're not saying that that entitles us to summary judgment. What we're saying is that's relevant to the applicable standard of care. That's what the industry does. John, can you go to the logo slide, please? You're going to hear, Your Honor, Mr. Kemp at this trial say that everybody does it, all the retailers do it. This is a real water investment pitch, Your Honor. It is taken from a YouTube video on our exhibit list that Brett Jones, the owner of Real Water, gave to potential investors. These are the stores that stocked his product and the retail or the distributors who distributed his product. Your Honor, on this slide are probably 24 different entities. There is one that audited Real Water, that's Costco. And by the way, they're being sued by the plaintiffs in other cases for not doing it well. But none of the other retailers or distributors listed on this slide, Your Honor, not one, besides Costco, audited Real Water. The reason they didn't is because of the subpart G exemption at 117.7 and the industry standard. Now, this is an item that Dr. Hutt cited as a reliance material in her report. If we go to Dr. Hutt's deposition, you heard Mr. Heidel say that this absolutely exempts warehouses, distributors, from that requirement. Dr. Hutt isn't aware of that. She doesn't know it. John, can you go to, let's start at page 110. Line 15, please. She realizes when she's asked about this exemption, Your Honor, that she's pretty far over her skis. And then she tries to dial her opinion back and say, no, the scope of my opinion was just Real Water in the manufacturing facility, not the distribution facility. I don't know anything about, I was not assigned to look at UNFW distributions. Can we scroll down, John, please, to page 111? starting at line 11 there, John. I don't know the content of the distribution standard and how they would address management of suppliers. So I would like to see the document. The document she's speaking of is the regulation itself. I don't recall the warehouse exemption off the top of my head. I don't know what subpart G is. Keep going, please, John. I don't know. Were you not aware that they were exempt from C, that should be GMP, good manufacturing processes, and supplier verification activities? And this is Dr. Hutt's answer, Your Honor. I know there are considerations for warehouse and distribution systems within the code. I don't recall exactly what they are, and I would have to look at the context. Judge, this is the regulation and the regulatory scheme that informs, that creates the industry standard of care. Dr. Hutt, the plaintiff's expert, is utterly unfamiliar with it. Mr. Heidel has explained what it requires and what it doesn't, and how warehouses like UNFW are exempt. Dr. Hutt is going to come in and tell this jury that we should have audited real water in an on-site audit once a year. UNFW should be able, in response, to say, the very law that you looked at, supposedly, in developing your opinions, exempts us from it. As long as there's a negligence count, or a negligence per se count, or a punitive damages count, Your Honor, compliance with the law is relevant. That's Robinson versus GGC Incorporated. That's Price versus Sinnott. And both of those are cited in our opposition. Both of those are Nevada Supreme Court cases. When the plaintiff alleges negligence or negligence per se, a defendant's acts in conformity with regulations becomes admissible. Not dispositive, but admissible. And I can argue to the court, excuse me, to the jury, the finder of the fact, that either Dr. Hutt has the standard wrong, or that we complied with the standard given the exemption. That's why this is relevant, Your Honor. That's why the plaintiffs are fighting so hard to keep it out. That's why, like a foundation of sand, the motion has moved from underneath our feet, because the original basis for it is utterly lacking. And the most recently asserted one is not much better. You've got the regulation, Your Honor. I'm happy to try to answer questions about it. I think it is dense.
I have a copy of the full regulation. Yeah.
But the bottom line is this, Your Honor. Parts of that are applicable to warehouses that deal in packaged and unexposed food, and large parts are not. And Dr. Hutt, when she misascribes an industry standard of care, has got it exactly backwards. And the regulations develop, they inform, they are responsible for the industry standard of care, and we absolutely have the legal right to tell the jury that fact. Now, they may not accept that. They may say, well, that's a big deal. If you're exempt, you should go above and beyond. I understand the jury's authority to do that. But there's not a case out there that prevents us in a negligence or negligence per se action from informing the jury that we have complied with the applicable regulation. And that's why the court should deny the motion.
Thank you, sir.
Thank you.
Sir.
The entire argument was based on this idea of we're just a warehouse. We're just truck drivers. Federal law treats us differently. That's the argument that they raised after the briefing was done. And that's exactly why we showed you the agreement. They're not solely engaged in storage. They're not just a warehouse. In this case, they are the purchasing agent. They indemnified Whole Foods. They undertook these responsibilities. And now they want to come into court and say they're exempt from it. There's myriad problems with that, Your Honor. The first being is it's not true. The federal regulation says if there's any exemption that applies, it's to entities engaged solely in the storage of food. They're not engaged solely in the storage of food. We went through that with the agreement and they did not respond. They did not argue that they were engaged solely in the storage of food. They did not use the word solely. They didn't address a single thing about it, Your Honor. That's a tacit concession that they're not engaged solely in the storage of food. Mr. Neale suggests, well, as long as there's a negligence count, a negligence per se count, and punitive damages count, that this is relevant. First, there was negligence pled in the complaint, but we're allowed to plead negligence in the alternative. It does not mean that this is in terms of compensatory liability. This is a strict liability claim. It's a strict liability case. An alternative claim.
How do I handle that though, from an evidentiary perspective?
Well, you know, I'm sure when we submit the pretrial memorandum, we'll exclude the negligence claim in there. I mean, we haven't addressed it yet, but
I'm not forcing anyone to do anything right now. But I think at some point I have to, whatever decisions I make from an in limine perspective, and even maybe dispositive motion perspective from time to time, might impact what the status of the pleadings will be.
I understand that. Yeah. In terms of the negligence claim, I think that argument assumes that there's going to be negligence at trial, which, you know, without confirming anything yet, I don't think that's going to be the case. Negligence per se, our negligence per se is not based on CFR 117. I mean, if there's a negligence per se claim based on the statute that we're saying is the standard, I'm not asking to preclude arguments on that statute. That's a completely different scenario. And just because there's a negligence per se claim based on one statute, that doesn't mean every other statute that exists, whether or not it applies, is fair game to argue to the jury. That leaves punitive damages, which is really the only thing we're talking about here. And that just brings us back to the fact that they wanted, you know, hold up this inapplicable statute, basically assume that it exempts them when it doesn't. Clearly, they undertook the obligation to do this and make a misleading, confusing argument based on inapplicable federal law. I think this is exemplified perfectly in the deposition clip that Mr. Neale played for you. I apologize, I'm not sure if it's Dr. Hiddell or Mr. Hiddell. But when Mr. Neale was questioning Mr. Hiddell in the deposition, he said, well, isn't it true that, you know, entities solely engaged in the storage of food are exempted under 117? And Mr. Hiddell acknowledged that. But what I thought was most striking was that Mr. Neale never brought up the fact that UNFI was not engaged solely in the storage of food in this case. They were the purchasing agent for Whole Foods. They indemnified Whole Foods. They undertook the obligation to ensure the safety of the product that they were distributing. So we don't know what Mr. Hiddell would have said under those actual facts, which are the facts present here. And this is why the argument is confusing, misleading, and irrelevant. Under UNFI's proposed argument, based on the federal regulation, no one is responsible for conducting any type of food safety precautions. And audits is one of them. You know, I think what we've seen is that audits, you know, going onto these premises would have been glaringly obvious to most people that we've got some serious problems here. We could have, you know, more likely avoided where we are, being where we are today. But that's neither here nor there. They didn't do anything. They didn't request audits. They didn't request customer complaints. They didn't do a single thing. And that's what Dr. Huff's opinion is that they disregarded every elementary safety precaution that there could be. And UNFI wants to come in and argue to the jury, no, we didn't do anything. We didn't act with conscious disregard of safety. Federal law allowed us to do this. We were just doing what federal law says. Well, that is not true. Federal law does not say that because they weren't engaged solely in the storage of food. They were purchasing this food. They undertook the obligation to ensure the safety of this product that Whole Foods was selling. And to suggest otherwise is not relevant, it's confusing, and it's misleading. And even if there is some tangential relevance in this somewhere, I can't see it, but even assuming there is, that relevance is overwhelmingly outweighed by the risk of confusion from these arguments. Think about the impact of this argument. Mr. Neale summed it up for you. Oh, the jury may say, oh, you didn't have to comply with federal law. You should have done more. That's what they want to argue. They want to tell the jury, oh, no, we didn't do anything wrong. We were following federal law. That's not true, and it's prejudicial to suggest that. They want to raise the specter of this federal immunity. And I'm glad to hear that they're not arguing preemption or not suggesting it's summary judgment as a matter of law, but they're still trying to do it as a matter of fact by bringing in an inapplicable exemption that doesn't apply to them under the facts of this case and holding it up as somehow their conduct is blessed by federal law.
And tell me why, because, I mean, I sit back and I'm trying to, and this is one of those, this is probably why it takes more time, because it seems like these motions morph into something that I didn't read or realize what was on the table. And here's my point. What do I do with the NFW versus NFI issue? Are they the same, or, I mean, that hasn't been fully explored. Just as important too, I mean, I don't want to say it, I understand voluntary undertaking. I remember that was a big case in the endoscopy. That was a big issue. And I remember when they were arguing, and I was just waiting for Mr. Egbert to say, well, Judge, I undertook it. Once he said that, are you talking about voluntary undertaking, right versus sham? And I cited the restatement of tort second. I understand that, but I had to first hear it. and he said yes. But my point is this, what do I do with these facts? Because we're kind of, what do I do with the UNFW versus UNFI? I understand voluntary undertakings, I get that. That's not a heavy lift from a legal perspective. I mean, the case law is pretty clear. But how do I deal with this issue? And I don't mind saying it for the record. I mean, I did go and pull a copy of the CFR, but I only had 117.7, right? And I can see now there's a lot more to it, and I didn't realize it at the time, so I got to look at this. But what do I do with those issues?
Well, first, Your Honor, let me say I do understand that we have gone beyond the briefing in this one. And I normally would not do that unless we thought it was important.
Well, I can tell you this is kind of how I look at those issues. And and understand these are, is this an limiting motion? Here's my point. And yeah, it's an limiting motion. When the issues are raised and regarding the applications of fact and law, and it's in the record, once it's in the record, I get stuck with it. That's probably the best way I can say it. And so I have to deal with it. And if I don't deal with it the right way, Supreme Court will look and say, oh, you should have dealt with this, Judge Williams, and they can make a ruling.
And Judge, just to...
So I understand that, I do.
Just to be fully clear, this provision, this regulation is front and center in the motion. I mean, it's...
No, it's there, but I mean, when I looked at it, for example, and I'm not saying, understand this, I'm not saying anything in any negative way regarding anyone, both sides. And yes, it's in the motion, it is, because that's why I made a copy of the specific provision of the CFR, because it was in there. But it wasn't as clear as to the application of it when I was going through it, and that's why I pulled it. And that's why my initial question was, okay, what does this have to do with what I'm doing? Now I understand, and now I have copies of everything, and so on.
And I'm not taking it as in
So
that way.
I'm not criticizing plaintiff or defendant.
And I understand that, Your Honor. It's just, I agree with you. I do think it's important that we do stick to the briefs and the issues that are raised as much as we possibly can. And this one did morph a little bit in terms of the arguments because of arguments that were raised after the briefing. So it's not in interpretation of what you're saying. It is a genuine feeling because it is important that we generally try to stick to what the motions and issues are that are briefed and raised to the court, in my opinion. And I don't like going beyond that. But in this instance, I think some of the arguments that came up after the motion was briefed are important and relevant to raise in this context. And so with that, I'll go to your next question, and what do you do with the distinction between UNFW and UNFI? I think in this instance, at least with respect to this issue, it's my understanding that there's no disagreement between the parties that for the purposes of this, in the contract with Whole Foods, there is no distinction between UNFI and UNFW.
We agree, Your Honor. The court need not worry about that distinction.
The next thing I want to address is this graphic that was put up on the screen of all the different sellers of real water and how Costco was the only one to conduct any type of food safety audit and that Costco is being sued. Well, yes, Costco is being sued because they sold real water that caused harm to multiple individuals, and they've been sued in those cases. I do think that for context for the court, we've also sued the auditor that Costco hired because the auditor went to the premises and found some very significant deficiencies and failures, and one of them being that there was no one at Real Water who was qualified to make a safe product for human consumption. This is what the auditor found. And this audit was in Whole Foods records. It was given to Costco. It was available for other people to review. And I know Mr. Neale will want to, comment and say, oh, well, they did a re-audit and, they fixed these issues. Well, those are very, very...
Here's another thing. I mean, there's a lot at stake in this case. I get that, number one. Secondly, and from the trial judge's perspective, and I've been doing this for a long time, I don't even like the meet and confer rule. I don't mind telling you that. Because to me, it's a waste of time. You make your determination as to whether you're going to accept, oppose or not oppose a motion to limine when you look at it and read it. So, and I would anticipate at least 50% of the time when you're doing the meet and confer, you're saying to the other side, look, well, I don't know if I can, I got to see it first. Right? So why are you meeting and confer? Because you can always file a non-op. And the reason why I look at that in this regard, and this is just my perspective, I learned a lot during these emotions. And it seems like that rule was put into place to maybe alleviate the docket. And just as important too, I'd much rather spend 2 or 3 hours vetting a very subtle issue that's critical to the case than having 15 seconds to make the decision sidewalk. Because I don't mind saying this, I've made decisions sidebar and I go home, I said, maybe I should have gone the other way on that one. Sometimes it happens, I mean, you know, but if I had time to think about it, I'd have a much higher level of confidence. And then sometimes you don't know all the facts to make the appropriate call, right? But go ahead.
Your Honor, I can say on that,
I'm gonna have to deal with it anyway.
and, you know,
That's all I'm saying, I gotta deal with it.
I can at least speak for myself to say that the hard work that the court puts in and the time that the court puts in is appreciated.
And the bottom line is I gotta deal with it because it becomes an appellate issue. And it doesn't matter, I gotta deal with it.
I think different judges do it different ways, and if for my money, I think you have the right idea. So I don't want to get too far afield and into the audit situation or what happened there. I think it's
So your position is, because I'm a review, I don't mind telling everyone this, I got a copy of the CFR now in total. I have the different sections already tabbed by my law clerk. You're taking a position as a look, Judge. They're doing more than acting in the capacity of just a warehouse as it pertains to the storage of unexposed packaged foods. And that's your position. I understand the defense position as far as your standards are concerned. I understand how they're saying, look, Judge, I remember there's 2 other claims out there, oh, actually 3. There's 2 other claims specifically involving negligence and the negligence per se claim. And then also, Judge, this might touch upon Chapter 42. I get it.
Yeah, Your Honor, and I think stated another way is the negligence per se thing, it has no relevance to that. We're not moving on this statute, and regardless of the negligence or negligence per se, with punitive damages, it equally doesn't have any relevance for 2 reasons, like you said. 1, because they're not engaged solely.
No. That's what you said.
Well, as you summarized.
No, I was just summarizing. When I summarized the respective positions, right?
I did not mean to suggest that you are holding that.
No, that's okay.
You summarized our point.
Yes.
On that one point. And then I would just add to that we are also saying that the exemption doesn't apply because UNFI undertook the obligation to do this in the contract. So those are 2 separate things. They're the purchasing agent, so they're not engaged solely.
I need a copy of the contract.
I will have one printed and submitted to you.
You want a contract between them and Whole Foods, or a contract between them and your?
I would think, from what I can tell, based upon the arguments made, it would be the UNFI contract with Whole Foods where they're performing more than one function.
You want the real water contract, the real water contract.
Is that, I don't know, you gotta tell me. Based upon the argument, it sounds like to me, we're making references to the UNFI contract.
Your Honor, Joel Odou on behalf of Real Water, there are other issues with that contract and affects Real Water Tennessee. And so I don't know that we want to broaden the scope of the inquiry because I don't think it's relevant, but again, it's plaintiff's motion. I don't want to tell them what to do.
Maybe, is this safe to say, there doesn't at least appear, unless I misread thing, look at my notes here, I'm not really to consider the distinction between UNFW and UNFI.
Agreed, Your Honor.
Okay, I'm not looking at contracts now. I'm listening to argument. Go ahead.
Yes.
And what's been put in front of me? I don't want to open up Pandora's box. It's your case.
And so the 2 reasons, they're not engaged solely in the storage of food because they're the purchasing agent. And 2, they undertook the obligation to perform these food safety precautions. And because of those 2 things, it would be confusing, misleading, and unduly prejudicial to let UNFI come in and say they qualify for this exemption under federal law when they don't. Unless the court has any other questions.
I know.
Thank you.
So, Your Honor, just briefly, 3 things. Number one, there was no voluntary undertaking of an audit responsibility. We agreed to indemnify Whole Foods. We absolutely agreed to enforce our robust food safety policies. We agreed to do everything we could from the time of receipt to delivery to ensure that food did not become adulterated under our watch, and it didn't. A voluntary undertaking analysis would be relevant if we had said, despite the exemption, we're going to go audit Whole Foods, or excuse me, we're going to go audit Real Water and do it correctly. That would be a voluntary undertaking that introduced exposure or potential liability for not doing it right. So a voluntary undertaking doesn't apply here, Your Honor. The warehouse exemption applies. I want to congratulate Mr. Pepperman for his creativity, but the warehouse exemption applies to packaged unexposed foods, whether the warehouse owns that food or not. It applies to FedEx and it applies to UNFI. If it is packaged unexposed food, the facility is exempt from the requirement. It has nothing to do with whether you bought the product. I can be a purchase agent, I can be a shipper, I can be anything in between. The exemption is silent as to all that. Just as Mr. Heidel asked, if the food is packaged and unexposed, the exemption applies, period. In terms of complexity, Your Honor, you saw how quickly Mr. Heidel dealt with the issue. It took about 120 seconds, as I recall, to say that, yeah, the exemption is exactly what you say it is. It applies here. And UNFW, so long as it doesn't reformulate, relabel, or repackage the product, doesn't have to do any supplier verification.
I understand.
Finally, Your Honor, I hope the court is as struck by the irony as I am that the plaintiffs have an industry standard of care expert and are moving in limine to keep us from introducing evidence concerning the industry standard of care. Even if they dismiss their negligence count, even if they dismiss their negligence per se count, the industry standard of care is relevant for punitive damages. This evidence comes in. It would be error, Your Honor, to exclude it. Unless the court has questions, I'll ask the court to deny the motion.
Okay. Thank you, sir.
Thank you.
Okay, they're fine.
Sure, thank you.
Next up, Mr. Kemp.
Judge, the next up is the entitled motion to eliminate number 15
I have it right
to
here.
preclude cumulative defense expert opinions. I talked to Mr. Neale about this briefly. Basically, this motion seeks to enforce the standard rule that you can't give cumulative evidence. There's 6 different defense experts that all want to give opinions on Haley's case on turmeric and Mr. Belsky's case on kratom. And most of them didn't say anything about it in their initial reports, but they just said, I concur. So, we can argue now, but I got thinking about it. Some of these experts are probably going to fall by the wayside in other motions. Because, for example, Dr. Alsina hasn't even been deposed. He didn't show up during his deposition time period. And even if he was deposed, he's not giving an opinion. He's giving an algorithm. So I think his opinion is going to be struck. I think probably Dr. Tender's opinion is going to be struck. It's speculative. But that changes this argument a little bit because, I think it's pretty clear that if there's 6 different medical experts all say the same thing, that you're going to have to preclude someone. If there's 1, if there's 2, in some cases, Judge Gordon has allowed 2 from different disciplines. That's one of the cases they cited. So I'm thinking
Let's either skip it or
okay,
not.
I'm just trying to say why it was
I don't tell you, I may look at it slightly different than Judge Gordon. I look at it, and this issue's come up a lot in medical malpractice defense group, for example. You might have a standard of care expert, and typically you get one, and there's a difference between a standard of care expert and say maybe treating physicians, you might have multiple there from different disciplines. But at the end of the day, you know, on standard of care expert, you know, that's when it comes cumulative.
Yeah, Judge, I'm not asking the court to rule on now.
It sounds like to me you might better work that one out.
Well, I think what we ought to do is rule on each one of the other experts that come back in your position.
Okay.
We don't have any objection, I don't have any objection, Your Honor, to kicking it down the road as Mr. Kemp suggested.
Because at the end of the day, we know what cumulative testimony means. We do.
And I think at the end of the day, Your Honor, once we know how many experts survive and which parties survive, we'll have a better idea of what might not be cumulative.
Yeah, that's what I think.
Yeah, I agree. And so I kind of look at it slightly different than Judge Gordon. That's one reason I'm bringing it up. It might be because of my medical malpractice defense background. And when I look at standard of care, that's, to me, a really good example.
Well, you know, in fairness to Judge Gordon, his opinion is pretty tight. But anyway, let's not argue now.
Yeah.
The next one up is the summary judgment for punitive damages on UNFW, which I anticipate is probably going to take a little while.
I think that's going
we
to
should take our afternoon break.
Yes, I think so. You agree?
Yes, sir.
All right.
Now everybody left.
Department 16, now go back to work. Please be seated. Your Honor, looks like we have three counsels out.
Okay, that's
Mr. Pepperman and Mr. Parker.
They don't need to, but this covers 3 issues. Let me see here. We're just reviewing, we got a copy of your defendant United Natural Foods West, first stipulated motion in limine. I'll sign that this afternoon.
Thank you, Your Honor.
And just for the record, does that go to any specific in limine motions that are on file? I didn't think so.
It does not, Your Honor. Those were agreed to and did not require a motion.
I understand.
Can we be reminded what day our pretrial memorandums are due, or the joint pretrial memorandums due? And trying to figure that out because we haven't gotten to most of the motions, pretrial motions yet, so.
I thought didn't we come to a date on that?
It was the 30th of August was what Tori done.
Is that August 30th?
The joint pretrial.
Right. And August 30th.
30th, thank you.
Okay, so what are you going to
It was with Hardy, I think, that's in this one.
Thank you, Your Honor. Next up is United Natural Food West's first motion for summary judgment, which deals with the punitive count. And there's a good bit of overlap with obviously with the standard of care argument you just heard, so I'll try not to belabor that. And I know the court's obviously well aware of the standard in Title 42 requiring oppression, fraud, or malice. I'll just point out at the outset that there was no attempt to argue oppression or fraud, and I think that we're only dealing with malice, and I think within that we're only dealing with implied malice, which of course is despicable conduct engaged in with a conscious disregard for the rights and safety of others, and as the court is well aware, the statute defines conscious disregard as knowledge of probable harmful consequences of a wrongful act and the willful deliberate failure to avoid those consequences. So in essence, I need to do something bad. I need to know that people are going to be harmed by that. And I have to consciously decide that I don't care to avoid that harm and that they may suffer the consequences of my wrongful act. I'll just point out at the outset, Your Honor, that is not a recipe for success for a food distribution company. It almost is anathema to the existence of a profit-based service company. It just, to be guilty of a wrongful act that you know is going to hurt someone and choose not to do it, you have to be inviting an outbreak, inviting an adulteration, inviting harm to your customers and not care to avoid it. I would point out at the outset that that's an implausible, if not impossible, thing to imagine a food distribution company deliberately doing. We know from the Fitchner case, of course, that the conduct has to evince a culpable state of mind and that it has to exceed recklessness or gross negligence. And finally, I know this is familiar ground to the court, but the evidence supporting it has to be clear and convincing before it's even submitted to the jury for consideration. So if we shift from that standard, Your Honor, to the facts of this case, let me start with some very, I think, obvious, but obvious statements that nonetheless bear repeating. Number one, UNFI did not adulterate this product. This product did not become adulterated in UNFI's possession, custody, or control. UNFI did nothing to put the hydrazine in the product, to approve the design specifications, to increase the hydrazine, et cetera, et cetera. The other thing I'll mention to the court is that at the end of an exhaustive regulatory investigation that involved the Centers for Disease Control, the Food and Drug Administration, and Southern Nevada Health, among others, there was absolutely no regulatory action, adverse regulatory action, taken against UNFW or any of the other retailers or distributors who, frankly, are collateral damage in this instance. Nobody suggested that they could have, should have prevented this. Nobody issued a 483, that's the bad inspection report, an EIR or warning letter. There certainly weren't any consent decrees issued or petitions for injunction. There was simply nothing imposed on UNFW or any other distributor or regulator, retailer, blaming them for this outbreak. The plaintiff's expert agrees that nothing we did contaminated or caused the outbreak. And I think, Your Honor, that, well, I'll leave it at that. But everything that happened from the time that UNFW received this product until it delivered this product, there is zero act or omission in that range, Your Honor, that has been called out as a culpable act, as a negligent act, as a act that contributed to the problem, or as a act that would form the basis of any punitive damages. So I want to review very briefly, if I can, Your Honor, UNFI and their role here, and I don't mean to be pedantic about it, but I think it'll help show what they're required to do and what they did in fact do under this scenario. John, could you pull up Exhibit J, please, to the motion for summary judgment. Your Honor, we're a distributor, as Mr. Pepperman has pointed out. We buy product and we store it, and then we get purchase orders from retailers. We don't decide what they buy, they do, and we fulfill those orders. This is a purchase order for real water that we received in, I believe this one is early 2021, where Whole Foods from our Moreno Valley Distribution Center ordered 108 cases of real water. Manufacturers then bring us, Your Honor, their product, page 2 of the same exhibit, John. They ship it to us. We receive it at our loading docks. This is Real Water shipping 24 packages, Your Honor, 24, I assume that's pallets of Real Water, to our Moreno Valley Distribution Center. We then receive that product, page 4 of the same exhibit, please, Mr. Stevens. John, is this page 3 or page 4? Okay, let's go to page 3 if we came up with the same. Maybe it's beyond that, excuse me. There we go. We then receive the product, Your Honor, on our loading dock. And when we receive it, this is the same inbound shipment of Real Water that comes to us in shrink-wrapped pallets of glued boxes containing sealed bottles. There are 3 layers of protection, if you will, between us and the product that we never open, relabel, reformulate, repackage. We do a visual inspection, Your Honor, and a black light inspection. John, can you highlight the pest odor repair cleanliness line? They call it a pork inspection. Every single thing that comes into the warehouse gets inspected. For pests, for odor.
And which exhibit is this again?
This is an Exhibit J, Your Honor, of the motion for summary judgment. It's the 5th page of Exhibit J. But the point there is, Your Honor, that every single shipment gets looked at, examined, and there's been no suggestion at all that that didn't occur here or that it occurred in a negligent manner that allowed a patent defect to escape detection. Not content with just the visual inspection, they then do a blacklight inspection where they're looking for biomarkers that would indicate either microbiological contamination or pest activity. And then an individual signs it to ensure that there's accountability at the loading dock. And that's true, Your Honor, of every single shipment that comes into every single one of the UNFW distribution centers. We then hold the product, and we hold it in a prescribed manner, Your Honor, so that it is less likely to be cross-contaminated with allergens or chemicals or sanitation materials. John, if you could go to Ms. Capadia's deposition at Exhibit K, page 129. This is the Vice President of Food Safety at UNFI, Your Honor, Ms. Rima Capadia. At 129, line 16 to page 130, 21, she describes the regimen of inspections that occur. That's Exhibit K to your motion, Your Honor. She describes the regimen of inspections, that they occur daily and weekly and monthly, obviously with increased detail as the time increment increases. But during those inspections, each and every product in the distribution center is looked at to ensure that it's stored in a manner that preserves the quality and safety of the product. I'm mentioning this because it's the opposite of what I think the plaintiffs will argue was the absence of any food safety measure whatsoever, which I think I heard Mr. Pepperman say. While these products are held at UNFW, they are subject, John, the food safety policies, please. Bates number 804. They're subject to a number of different robust food safety policies. This is the food safety policy that governs the distribution center operations. 824, John. These are the good storage and distribution practices that govern the storage and holding of food products. 906, please, John. This is the food defense plan, which guards against intentional adulteration. And John 930. This is the receipt, storage, and handling of goods policy that applies. And Judge, there are literally dozens more pest control policies, sanitation policies, loading and storage plans. All of those apply, all of those are enforced. There has been zero, and Your Honor, we did not inundate the court with those policies themselves, but the deponents referred to them in their testimony. So they are not individual exhibits to the motion. But there's no evidence at all, Your Honor, that those policies either weren't in place or weren't followed, or that the violation of them or the disregard of them somehow contributed to any of this outbreak. That, Your Honor, I would suggest is the opposite of despicable conduct engaged in with a conscious disregard for the rights and safety of others. It in fact evinces laudable conduct that's engaged in with a conscious regard for the rights and the safety of others, which is the only plausible motive for a food distribution company. The bottom line, Your Honor, again, is that UNFI did everything they could to minimize the chance of contamination while the product was in its possession, custody, and control. But much of that is required. And just because they're good at it doesn't mean they can't do anything wrong. But John, if you could go please to Dr. Hutt's deposition at page 106. Your Honor, Dr. Adams Hutt is again the plaintiff's standard of care expert. She's a qualified individual in the food safety world and is the one who opines about what UNFI should have done in this case. When she was asked, lines 4 through 13, please, John. When she was asked what the gold standard for food safety is right now, if you're a DC, that's distribution center, Your Honor. She said, well, what do you mean gold standard? And I said, well, tomorrow you're named CEO of the largest distribution company in America, Cisco. You've probably seen their trucks on the street. What do you do? What do you do to make sure your distribution centers are certified? Her answer is, I would do an SQF audit. SQF is safe quality food, Your Honor. It's completely voluntary. It is above and beyond any required inspection. It's something that the distribution centers pay for. It's something that they ramp up for. It is exhaustive. And it is, as Dr. Hutt said, the gold standard. John, if you could pull up, please, the Rockland SQF certificate. It's exactly what UNFI did. Every distribution center that distributed real water into the state of Nevada was voluntarily SQF certified. This is the 2018 certificate for the Rockland, California distribution center. And this, again, according to the plaintiff's own expert, is the gold standard. Above and beyond, completely voluntary. It's what she would do if she were the CEO of a distribution company. It's not easy to get, John, if you could pull up the audit. It requires a pretty exhaustive audit that takes multiple days. It's unannounced. It is exacting. It is people like Dr. Hutt who do the audits. John, if you could just scroll through, it's, I don't know, dozens of pages. And it details the observations in the DC. It insists on the corrections. And all of this is a prerequisite for getting that SQF audit. Companies do it, Your Honor, because then they can go to their customers and say, you can rest assured we're SQF certified. We've achieved the gold standard. We've done everything possible. It is the high water mark for food safety, and we are attaining it. Again, Your Honor, that's the opposite of despicable conduct engaged in with a conscious disregard for the rights or safety of others. It's 180 degrees from that. The plaintiffs are asking you to allow the jury to punish UNFI for having a premier food safety program. The plaintiffs insist that in addition to all that, UNFI should have audited real water and every other one of the 10,000 suppliers who provided 100,000 products. Let me, that food safety has to somehow go beyond receipt, start before you receive the product. And I want to show the court how UNFW nonetheless did impose requirements and hold real water's feet to the fire. Exhibit L, please, John, the supplier agreement. Your Honor, this Exhibit L to the motion is UNFW's contract supply agreement with Real Water of Tennessee. And you'll later in these motions hear more about Real Water of Tennessee and who they are and who they aren't. I'll leave it at this for now and invite Mr. Kavanaugh to correct me. But Real Water of Tennessee was, as its name suggests, at one time located in Tennessee. They were an affiliate of Real Water here in Las Vegas. The Vegas entity owned 50% of the Tennessee entity, but then in 2019 bought the entire remaining share and operated it from Vegas thereafter. This is the only contract. John, if you can scroll down, please, to page 5 of the contract. Let's go to paragraph, it's further up than that. It's going to be paragraph 3. Yeah. So number one, Your Honor, we require Real Water, like all of our suppliers, to abide by federal law. And that's not a fig leaf here. I'll explain what that means in terms of bottled water companies. But I'll remind the court that this is how businesses obligate each other, is to impose contractual obligations on one another. And it occurs to me that the jury instruction on, I don't think it's a last clear chance instruction, but it's 409. It's the right to assume that others with whom you're dealing are following the law until you have a reasonable indication that they're not. So number one, we require them to do it. And in terms of bottled water, what that means, Judge, is they have to do very specific testing. John, I don't know if I've given you 21 CFR 129, but there are federal regulations that govern how a bottled water company has to be run. And don't worry about it, John, we'll skip to something else instead. But among other things, what it requires is that their product be tested on a regular basis. And they have some pretty basic tests that I believe are required to be done weekly, and then a more exhaustive battery monthly, and then a super exhaustive battery annually, and I want to look at that if we can. John, could you pull up the Western environmental testing, please? So pursuant to the requirement in the contract that Real Water test its product, it did just that. It invited independent accredited laboratories into its facility to collect water at prescribed intervals. And this, Your Honor, I don't know that we attached this exhibit. No, we did. I'm sorry. I do have an exhibit number. I'll get it for the court. I apologize. But this is an example of, I believe, the annual testing that Western Environmental did for Real Water. John, could you go to page 9, please? And I just want to give the court an idea. We've talked in the abstract about testing for hydrazine and the fact that that wasn't done. What was done, Your Honor, is exactly what's required by the EPA and the FDA, and that's what they call a 50-state analytic list. It's every chemical they can imagine, I think. But on page 9, we see the PCBs that are tested for. John, can we go to page 11? Page 11 has the semi-volatiles. Page 12, please. Volatile organic compounds. Page 21. The benzo chemicals, page 27. A battery of pesticides. This goes on and on, Your Honor. I think it's 40 plus pages of tests for this litany of chemicals and potential contaminants that UNFI required Real Water to do, and that Real Water did. And there was no indication anywhere, Your Honor, that Real Water ever failed to do it, or that they got a test back at all during their compliance testing that indicated the presence of a toxin in the pathogen. Now, if they had, can we go back to Exhibit L, please, John, the contract? Page 5, paragraph 10. If they had, UNFI obligated them to do certain things. You're going to be told that we never asked for an audit. That's not correct. We did insist on the production of audits. We insisted on the production of any non-routine, John, must be the next page. Yeah, starting there, thank you. In the quality assurance paragraph, we said, you have to give us any audit that we ask for, and you have to notify us specifically and immediately of any audit that indicates the presence of any pathogen whatsoever. So, Judge, we are requiring them to do that testing and inform us of any red flag. This is the equivalent of you know, the Titchener case. Hey, real estate agent, if you see an appraisal with somebody else's name on it, you better let us know right away. Well, Titchener punitive damages were allowed because they were told about it, and they nonetheless proceeded with the foreclosure. Here, the exact opposite happened. There was no red flag raised. There was no failed test. There was no non-routine audit. There was no compliance testing gone bad. Your Honor, the next section I'm going to largely skip, but just remind the court of. Can we go to 117, please, John, 21 CFR 117? Because this is the section where plaintiff says, we don't care what you did in your contract. We don't care what you required in terms of testing. We don't care what you required in terms of affirmative obligations to inform you of an audit. We think you should have done an annual audit. And I'll just simply remind the court that the Food Drug Administration says something very different. They specifically exempt distributors from the audits. So to put that differently, Your Honor, the plaintiffs are asking you to allow the jury to consider punishing United Natural Foods for not doing something that the FDA specifically says they do not have to do. I'd suggest to the court that that would be error. I would have played Mr. Heidel's deposition clip, Your Honor, where he says, yep, you're right. The warehouse exemption applies to anybody moving, holding, delivering, or receiving packaged unexposed food. And I'll just point out, please, John, if you could pull up the Hutt deposition, page 113 to page 114, that the plaintiff's expert acknowledges there is a warehouse exemption. She just doesn't know what it says. So the entire basis for punitive damages is the failure to audit. Dr. Hutt says that failure to audit is the one thing you did wrong. She says, I know there's a warehouse exemption, line 22, John, to page 114, line 21. I know there's a warehouse exemption, but I don't know what it is. We asked her at line 23, you looked at part 117 in developing your opinions? She says, yes, I did. And then on page 113, Your Honor, line 10 through 14, we ask if part 117 exempts distributors that are engaged solely in the storage of unexposed packaged food from C&G. And her answer was, I don't know, I can't read a regulation like that. John, if you could, thank you. The entire basis for the punitives motion, Your Honor, is lacking. The plaintiff's expert conceded that she doesn't know of a single distributor who audits all of its suppliers. She admitted, Your Honor, on page 110 of her deposition, that she's not familiar with the distribution standard. She doesn't know whether the SQF audit, that gold standard, requires distributors to audit their suppliers. Spoiler alert, it does not. And John, we know that, if you could go to the logo slide again, please. We know that because each and every distributor and retailer who dealt with real water over the course of the years, except for Costco, did exactly what UNFI did and didn't audit. Now, I don't know that they did as much as UNFI did in other regards, but I know that the plaintiffs are asking you to allow the jury to punish UNFI for doing exactly what all but one of the entities on this list did. And this list is far from complete, Your Honor. When we pull up the distribution documents at trial, there are going to be dozens and dozens, if not hundreds, of retailers who received real water, not one of whom besides Costco ever audited. No entity, Your Honor, despite what the plaintiffs say is obvious and should have happened, ever terminated real water from its contract for quality products. So even Costco that audited never terminated. They stopped buying real water products because they were selling so much of their own private label Kirkland that they wanted that shelf space. In addition to all that, Your Honor, real water was audited by Southern Nevada Health every year. And every year, Your Honor, Southern Nevada Health passed real water. Now, we could have a legitimate debate about whether those audits were robust enough or not, but when UNFI contractually obligated real water to follow the law, they know that there's an audit every year. They know that Southern Nevada, if it sees problems, will do a non-routine audit. They know that real water is contractually obligated to inform them of that. That never happened. Now, the plaintiffs have maintained in their papers, Your Honor, that Shaw's, Albertsons, Stop and Shop, Food Lion, Kroger's, Winn-Dixie Publix all audit. I want to point out to the court, those are entities that bought real water. They never audited, Your Honor. They never audited. And as the deposition testimony of the plaintiffs miscite makes clear, what they did was they only audited private labels, not branded products like real water. UNFI did what Whole Foods does, they audit some. They did what Target does, they audit some. They did what SuperValue does, they audit some. They do that risk-based analysis that we talked about in the regulation earlier. They decide which suppliers need the most help. They focus their resources on those suppliers. But Your Honor, intentionally electing to put your finite resources where they might do the most good is not conscious disregard for others. It's not a wrongful act, and it doesn't entail a probable harmful consequence that you willfully disregard. So, Your Honor, I'll just close with this. There is zero evidence of a red flag. There's no recall of real water ever. There's no warning letter prior to this incident. There's no warning letter from Southern Nevada Health or FDA or EPA or anybody else to real water prior to this outbreak. There is no non-routine audit of real water prior to this outbreak. There is no receiving inspection of real water product that UNFI saw each and every day that indicated any sort of a problem, much less a systemic problem at real water. And there is no test that real water did on its product by independent accredited laboratories that ever suggested the presence of a pathogen or toxin. There's simply no evidence of a red flag whatsoever, including, Your Honor, a customer complaint that UNFI received. Now, you've seen and heard much about phone calls, emails that real water got. There was nothing that real water ever passed on to UNFI, to Southern Nevada Health, to FDA, to Costco, or to NSF, the entities that did audit them. UNFI never got a complaint from a single customer. Whole Foods, Natural Market on the corner, Sprouts, everything in between. And as far as we know, UNFI, according to their testimony, real water, let me try a third time. Whole Foods never got a customer complaint. There is simply no evidence whatsoever of a red flag that UNFW overlooked. And because of that, Your Honor, there's certainly no clear and convincing evidence, and as a consequence, there can't be any malice, express or implied, or conscious disregard, which I'll remind the court, only because it's so far removed from what we just described, but means the knowledge of probable harmful consequences of a wrongful act and the willful or deliberate failure to avoid those consequences. If Eurofins had come back and said, this water tested positive, it's got chemicals in it, it's going to harm your customers, and UNFI had nonetheless distributed that, then arguably there's a red flag ignored, and arguably there'd be implied malice and conscious disregard. But UNFI did exactly the opposite. They had good policies, they had good inspections, they had SQF certification, and on top of all that, Your Honor, they voluntarily held some audits of suppliers that demonstrated problems. You can't possibly allow a jury to punish an entity for that. They did exactly what everybody else in the industry was doing and then some. I'm happy to answer questions the court might have. I'll just close by saying there has never been a suggestion that UNFI could have done anything more from the time it received this product until the time it delivered this product. Those are its obligations, and those obligations were well and faithfully discharged, and the court should grant summary judgment as a consequence on the motion for partial summary judgment on punitive damages.
Thank you, sir.
Thank you, Your Honor.
Mr. Kemp?
Your Honor. Your Honor, just as an aside, that chart he showed you of the 30 suppliers, there have been no contracts produced for any of those suppliers except for the Costco and the UNFI one. Some of those suppliers are secondhand purchasers. And what I mean by that, Terrible Herbs, for example, Nevada Beverage buys it from Real Water, and then Nevada Beverage sends it to Terrible Herbs. So we don't have any indication that any of these people had a direct contract with Real Water, such as UNFI. And I'll point out, we've been going through the production, the Real Water production. I would like to see some of those contracts because I think they will cast negatively on Mr. Neale. So anyway, for Mr. Neale to stand up here and say, everyone is doing the same thing we're doing, and point to a slide of 30 entities, then number one, there's no evidence they were doing business with Real Water. Number two, I don't have the contracts. I don't know how he has the contracts. And so number three, I have no idea where he gets the evidentiary basis for their supposed business practices. He's just making that up, Your Honor. But let's turn to what we do know. What we do know about what Mr. Neale calls UNFI and its role. These are the facts that he overlooks every time. Because remember, the word in the federal regulation is solely. It is not partially, it's not somewhat, it is solely. This is the only thing they do. The only thing, the sole thing they do is they're a distributor. To come within that federal reg, that's what you have to do. We know by the uncontroverted evidence that they are not solely a distributor. He stands up and says, oh, we're a distributor, we're a trucking company. That ignores the fact that UNFI entered into a contract with Whole Foods that it would do the purchases. Whole Foods wasn't doing the purchases. Whole Foods was giving them a list of items they wanted. UNFI was then going out to each supplier, like Real Water, negotiating the contract. They had a standard contract that they used, negotiating the contract with that entity and entering into a contract with the supplier. This isn't like a truck driver driving some produce from Vegas to Stockton or vice versa. This is a company that actually was the buying agent in this case. And on top of that, after entering the contract with Whole Foods, they entered into the contract with each supplier. Each one of the 12,000 suppliers, they entered into contracts with. And as I'll point out in a minute, half of them they decided to do these third-party audits, half of them they didn't. But that conduct in and of itself is uncontradicted evidence that they are not solely a distributor. So that Fed reg is clearly, as Mr. Pepperman said, not applicable. Okay, now, basically, and I've done a lot of preemption cases in my life, Your Honor. I don't know if you remember, but we did the RICO preemption, Mr. Jones and I, that went up to the United States Supreme Court. We won 9-0 on that after 13 long years. I did the Buckman versus PLC case. I was a member of the PLC in that case. I actually wrote the Supreme Court brief. You know, went to the argument. They gave me one of those little pens to give you. And I lost that case. But I know what a preemption argument is, Your Honor. Preemption arguments usually use the word preemption in them, all right? They did not file a motion for summary judgment for preemption. I thought they were going to file one because during the discovery, we heard these questions to people like Mr. Heidel about this warehousing exemption. We heard them from Dr. Hutt. So I thought they were going to file a preemption motion for summary judgment. But they didn't do that. And the reason they didn't do it is because this word solely kills them right off the bat. They cannot prove that they are solely distributors. So that's why they didn't file this particular motion, Your Honor. But since they didn't file a motion, they're trying to give preemption as an issue to the jury. They want to hand this federal reg to the jury and say, oh, we're solely distributors, so we don't have to do all this. That is not the proper role in our system of the jury, Your Honor. The jury doesn't get to make complicated preemption decisions. If they wanted to bring a preemption motion, they should have filed it with the court. But like I said, they didn't do so. Now, let's take a look at what they did that imposes liability for punitive damages. Can I have my first slide, please? You know, Mr. Neale says, quote, you are punishing UNFI for not doing something that the FDA says you don't have to do. Well, that's the warehouse exemption he's trying to get into. That's not what we're saying here, Your Honor. First, this is from Mr. White, I believe. Is this Mr. White? Yeah, Mr. White, who's the #2 food and safety guy with UNFW. This is just to show they knew the benefits of a third-party audit. Why do you do a third-party audit on the distribution centers? These are the warehouses. The same reasoning applies to any particular place. In order for a food safety program to work, it has to be audited by an external proponent to ensure that the facility is following the rules, policies, and practices of the food safety level that they're being certified in. You have to send someone into the facility, boots on the ground, to see that they're doing it right. They knew this. This is their #2 guy in food safety, understanding completely the purpose of a third-party audit. Got the next one, please. This is Dr. Hutt. Okay, this is Dr. Hutt's decision. You know, Mr. Neale goes, oh, she didn't know anything about the warehousing exemption. Well, that's because this isn't a warehousing exemption case. Obviously, they are the purchaser. So Dr. Hutt's basic opinion is it's one-step audit requirement. Anyone who's purchasing is the one that should require the audit. If they weren't the purchaser, if Whole Foods was the purchaser, Whole Foods should have been doing the audit. But they were the purchaser. They were the ones that should have been doing the audit. And this is her answer. It's the standard with the industry that the retail food industry does one step up or one step forward, I should say in this case. And that's the gold standard. That's what's done in the industry, and Costco is the best example of that, which we'll get to in a second. Can I have the next one, please? This is Ms. Castillo's testimony. Again, she's just verifying that Costco requires each one, every one of them has to be audited, okay? They send the third party, in this case they hired NSF, to every one of their suppliers. UNFI had 12,000 suppliers. As we'll see in a minute, they audited half of them, not the other half. Costco audits everybody. That's the standard in the industry, Your Honor. Next one, please. I'm going to try to go through these relatively quickly, Your Honor. Brown. Yeah, this is Robert Brown. He's, I believe, a Whole Foods employee. I asked him, have you ever given any consideration to having UNFI do this? Should you have UNFI do an audit on everyone in the industry? And he says, ideally, every supplier. This is the gold standard. He's admitting it. Next one, please. This is Raymond White again. So ask him again. If some people audit in Costco, he looked at the Costco agreement. So he said, so I asked him, so basically Costco is doing what UNFI is trying to do. Because I think we went over Mrs. Capedia's deposition and his deposition testimony that now that they realize, belatedly, that bottled water is risky like every other food product, now they're changing their program. Now they're going in and they're trying to audit everybody. So in any event, he is saying that UNFI is trying to do now what Costco did. Next one, please. This is Mrs. Capedia, or excuse me, this is Mr. Brown again. And we're just talking about Shaw's, we're talking about other retailers. These are purchasers. All of these are purchasers. That is the difference here, okay? If you are someone who is buying the product, that is the person that enters into contract with the supplier. That is the person that has the opportunity to put the audit requirement in. That is the person that has the opportunity to put the language upon request, you'll send me all the other audits, okay? And in this case, we know UNFI didn't put the third-party audit requirement in. They didn't put it in, not just for this contract, but for 6,000 other suppliers, they didn't put it in. And it wasn't because it was a nice, safe water product. They just didn't put it in 6,000 contracts for whatever reason. And when we get to it, I don't even know what the reason is because they don't know. I asked them, why didn't you do it to everybody? They said they don't know. But in any event, this is one of their witnesses, again, saying that back in 2004, they're doing inspections of the suppliers. This is not new and different, okay? This is something that's been done a long time. You know, Mr. Neale's going to stand up and say, oh, well, they weren't doing everybody back then. Well, maybe they weren't doing everyone back in 2004. But we know at least as of 2018, actually a little bit before that, Costco was doing everybody and some of the others were doing everybody. Next, please. This is Mr. White again. Again, he's with UNFW. And this is the point I just made. They didn't even ask for the audits. So Mr. Neale says, oh, Judge, they had an obligation under the contract to send us negative results. Okay, the contract says, quote, upon request, Real Water. Not only did they not require Real Water to do audits, but they didn't even ask them. And from the time period 2012 to present, the Real Water Tennessee contract's 2012. So for 9 full years, they didn't even ask for these audits. Maybe if they'd asked, they would have got the 2018 NSF audit. Next one, please. This is Mrs. Capedia. Okay, so Mrs. Capedia, she confirms they didn't request. During that time, we did not request any audits. Okay, they're requesting them now. They're requesting them now after this case. But during that time period, they didn't even exercise the contractual provision to request them. Next one, please. Again, this is Mr. White, the number 2 guy. Mr. Neale says the standard is you have to make a deliberate decision and have some conscious disregard. He called it the Fitchner case. Took me a second to realize he was talking about the Countrywide case. So under Countrywide, conscious disregard. How can it get better than this for a plaintiff? How can a question and answer be better than this? So you made a deliberate decision not to have annual third-party audits of bottled water facilities. Is that correct? Answer, UNFI made a conscious decision to focus our resource on high-risk items. A conscious decision, a deliberate decision. It's like I scripted it out for the guy. You know, what more do you need to satisfy Countrywide than this? And again, this is the same individual that I showed you the very first clip. He knew why they needed to do third-party audits. You have to get boots on the ground, and they made a conscious decision not to have boots on the ground. Next one, please. This is Mr. White again. Now there's a new policy. Okay, despite this so-called warehousing exemption, where the FDA is precluding them from being a safe company, they can't do third-party audits. Despite that so-called exemption, now they have a new policy. And the new policy is the Costco policy. Let's go in and do a third-party audit on everything. And that's what they should have done in this case, Your Honor. Next one, please. This is Mr. White again. So, in the motion, they talked a little bit about proximate costs. And they said, I didn't hear Mr. Neale mention it. I think it's because I caught whoever wrote their motion misciting Yamaha. So the motion, they cited Yamaha, but they didn't quote the third sentence of Yamaha that says it's usually a jury issue, proximate causes. So we argued proximate cause in the opposition. I'll just mention it briefly because I don't want to get sandbagged. So we asked him, assuming that you had all these problems that were flagged in the NSF 2018 audit, what would you do? He says they'd suspend him. That meets the proximate cause requirement in and of itself. If he was made aware of it, if they had NSF send him the audit like they should have, he would have suspended them. All right, next one, please. This is Mr. White again. Red flags. That's the term in Countrywide. So right here, the finding in the NSF audit that there's no one competent. I don't know how bad it can be, Your Honor. The audit found that there's no one competent in the whole company, referring to Real Water, in the whole company to make clean and safe bottled water. That's a finding. He says it's a reason to investigate. That meets the proximate cause requirement of Yamaha. This is a jury issue. Next one, please. Same thing. You know, if they were, same kind of thing, no staff that did HACCP. These are all on the NSF form that I think we're going to take a quick look at. If he was aware of it, they would have done something. But they weren't aware of it because they didn't require the audits and they didn't ask for the ones that some other people were requiring. Next one, please. This is Mr. White again. If they, another suspension, you know, no HACCP training, no quality control. Remember the first one was they didn't have anyone who could make water. These are other things they found. Suspension. This is approximate cost. Next one, please.
Your Honor, I just point out that the witness doesn't say suspension at all. The answer is exactly.
If we were aware, yes,
it
it's investigation. This one says investigation. I stand corrected, Your Honor.
We've got to not misquote the witness's testimony. I understand. Thank you, Your Honor.
Well, if we were aware of it, yes, it would be enough to start an investigation. Next one, please. Now, the next page, we get to suspension. If his answers are not, if they're not answers right away, he's going to suspend him. It's not going to be in a matter of months or weeks. It's going to be days. So if they didn't correct these 3 points, suspension. Next one, please. And again, this is Mr. Heidel, okay? He's the one saying that it's a terrible HACCP rating. Just as an aside, the warehousing exemption that Mr. Neale kept talking about with Mr. Heidel's testimony, he didn't confront Mr. Heidel with the fact that they were the purchasing agent. He just said, assuming this exemption applies. That's what he said. He didn't address the word solely in there. He didn't provide any indication to the witness whatsoever. So to suggest that that is somehow dispositive testimony, just not appropriate. But in any event, this is the worst NSF audit this guy's seen. Next one, please.
Hey, Will, let the judge see again the witness that made that last testimony.
Yeah, let's go back. Again, this is Mr. Heidel. So if you remember, and I think we're showing the NSF, I don't know if we are. Again, this all goes to the proximate cause issue that they argue in the motion, which is that there's no proof that even if we'd done an audit, we would have found something that made us stop deliveries. This is Mr. Phams.
Went kind of fast on that, but go ahead. He went kind of fast, that's all he said.
Right. This is Mr. Pham. Again, he's the Quality Assurance Director. Worst audit he's ever seen, back to the 2018 audit. All right, back to this audit. This is a pretty poor audit. Is this one of the worst or the worst you've ever seen? Yes, I have. That's the worst. The worst NSF audit he's ever seen, and Mr. Neale says we don't get to go to the jury on proximate cost. Okay? Next one, please. This is the food safety reg. I don't know why. I think we just wanted it in here for the word solely's in there, but I think we beat that horse already. Next one, please.
That's it.
Is that it? All right. Okay, turning to countrywide. Conscious disregard for the rights or safety of others, unquote. That's the standard. Conscious disregard for the rights or safety of others. I think we showed that just through Mr. White's testimony, Your Honor. He made the deliberate decision. It was a conscious decision. I don't need to show it to you again. They violated the industry standard. I think I pretty much exhausted proximate cause. Now, on one proximate cause argument Mr. Neale did make is he said, Costco didn't quit buying. Costco just had too much other products, so they didn't have enough space for it. So that's what he's telling the court the testimony is. This came up before, and I said the next time he did it, I'd correct it. Okay, this is that day. Can I have Castillo 76, please? And again, Mrs. Castillo is I think she's the assistant buyer for Costco. She lives in San Diego. And the testimony he is referring to refers solely to the San Diego store. Can I have page 76, please? This is just the testimony that the Costco Food Safety Division, this is an email from someone named Eric Pepperman to Lisa. They're members of the Costco Food Safety Department. Again, Mrs. Castillo is in the buyer's department. Mr. Benelkin's deposition is actually being taken, I think, in about 4 weeks, so he hasn't been deposed yet. But in this email, they are talking about the failed audit, referring to the December audit. March 4th, 2020, they're still talking about this failed audit. And the reason they're talking about the failed audit still is because now a year has gone by. Now it's time, it's actually past time, but you know, with COVID things slip a little bit. It's actually past time to do the next audit. So they're talking about the failed audit. Can I have page 104, 25, 104, 25, 105, 25? Just the bottom of 104. Okay, so this is another email. On March 4th, 2020, Lisa McCabe, next page. Do you recognize this as a Costco employee? She wrote an email. Again, she's with the Costco Food Safety Department. And again, this is relevant to the proximate cause issue. Mr. Neale's arguing there's no proximate cause to go to the jury because Costco didn't cut them off. She is in the Food Safety Department, and she says, quote, I would like to cut them off. Cut them off, unquote. Stop them from being a Costco supplier. But the only reason they didn't is because Real Water had still not paid for the 2018 audit. So they didn't cut them off yet because they were trying to get the audit bill paid. Keep going, please, Chris. And so other than the unpaid, they wouldn't do another food and safety audit. That's why they got terminated, Your Honor. They didn't get terminated because there was not enough shelf space to have Real Water all of a sudden. They got terminated because of this poor 2018 audit, and they refused to do another audit. And she says specifically there, if one of the vendors refuses to do another audit, they get, keep going, Chris. If one of our vendors refuses to take the food and safety, try to understand why.
He has to go back down. He's going to do that.
Go back up a little, Chris.
Yes.
And if that vendor refuses to do a food safety audit, is that a reason that Costco will terminate that vendor? This is Mr. Nardini. I think I pronounced that right. She's Costco's attorney. I think she's actually on the hearing today. But anyway, she testifies, if one of our vendors refused to take the food safety audit, yes, we would consider working with them to understand why. And if they don't comply, they're non-compliant, then yes, we would discontinue business. So what do we know? We know, one, Costco requires a food safety audit every year. We know, two, the last food safety audit that was produced either by Real Water or Costco is dated December 2018, and then there's a re-audit sometime in February. So there's no 2019.
As far as these food audits are concerned, are they random?
Well, no, they're not random at all. What happens is NSF, which is, there's a number of different third-party entities. One's NSF, one's the one Mr. Neale referred to, which is just, you know, I have a mental block on this, I can never do it right. SBQ maybe, SBF, something like that. So there's a number of companies, and in Costco, in Costco's contract, they actually have a provision that says, here's a dozen companies, you can use anyone you want to. So the supplier, in this case, the supplier's Real Water. The supplier contracts with the food safety people, and they come down, they do the audit, and then they mail it to Costco. Okay? So in this particular case, NSF was the one that was selected to do the audit. They actually did audits, I believe in 2016, 15, and 14, also on the facility. But what I would say is the last audit we know of is December 2018. We have 19, 20, almost into, because the operation was suspended in March 21. So there's no food safety audit during this entire time period, even though it's a requirement under the contract. And I've already shown you the email where the Costco food safety person says, I would like to cut them off, and I'm trying to get the bill paid, the outstanding bill for the 2018-2019 audit. So to suggest that these people were only cut off, or Costco quit ordering, I think he said, quote, Costco stopped because of space, unquote. Okay, that's a reference to Mrs. Castillo's testimony about the San Diego store. That, I believe, is contradicted by all of this evidence. But in any event, it is not the kind of situation where you can say that there's no issue of fact for the jury on proximate cause, what they would have done in the event that they had gotten the audit. And so for those reasons, Your Honor, we don't think that the proximate cause issue has any merit whatsoever. And I think I've covered most of the points. You know, you compare, Countrywide was a terrible case. I thought Mr. Fairback did a fantastic job proving it up. I think he was the plaintiff in that case. But in any event, Countrywide, they had one or two indications that this was the wrong address for the serviceman, and they went ahead and they foreclosed anyway. And then they found out they were definitely wrong, and they didn't do anything about it. In this case, if they had gotten that NSF 2018 report, they would have found that there were 8 out of 12 failures of the HACCP standards. They would have found that there's no one qualified to make water. They would have got what Mr. Heidel and Mr. Pham both agreed is one of the worst audits they've ever seen. They would have gotten an audit that Mr. White says would have triggered a suspension, or at least an investigation and a suspension if not corrected right away. I mean, this is what would have happened if they had just followed the industry standard and required a third-party audit. And so that's the reason that they should be subjected to punitive damages, Your Honor. We've cited some cases from, I mean, I think it's pretty obvious that if you don't follow an industry standard, you have conscious knowledge, which they did, of the standard. You're making a deliberate, conscious decision not to follow it, which they admit they did. I mean, that is a punitive damage case. And that's why the motion for summary judgment should be denied.
Thank you, sir.
Your Honor, it's late, it's Friday, and I'll be brief. I admire Mr. Kemp's ability to take what he has and turn it into what he wants. But that's not the state of the evidence. There's not a deliberate decision to avoid the industry standard. Mr. Kemp points out that UNFI was the buying agent That's a good thing. That's not a bad thing. That's why we have a contract that imposed requirements on real water, quality assurance requirements and food safety requirements that they followed. Go test your product, go get audited by Southern Nevada Health immediately. We don't have to ask for it. We can, but immediately tell us if there's a non-routine audit by a governmental entity. There are no red flags because there never was one. Immediately tell us if one of your tests turns out bad and shows a pathogen or toxin. Here's a red flag, you raise it if this ever happens. There never was one. The plaintiffs experts agree, the defense experts agree, there are no red flags in this case. Of course we recognize the benefits of an audit. That's why we do it for thousands of suppliers, even though we're not required to for anybody. Mr. Kemp is advocating that the court allow the jury to punish UNFW because it audits thousands of suppliers it's not required to, that didn't audit real water. That's the exercise of discretion. Yes, that may not be 100%. That may not be what happens ideally. That may not be the gold standard. Those are 3 snippets of deposition testimony that Mr. Kemp showed the court. Your Honor, we don't subject companies to punitive damages for failing to meet the ideal or the gold standard or doing a 100% solution. During other testimony, he showed you that the gold standard, according to his own expert, was to have an SQF audit. We did that. We did that with our own distribution center, time and time again. Every year, we do an exhaustive SQF audit of our distribution centers. And the gold standard, the creme de la creme, does not require us to go look at real water. Again, punish UNFI for going above and beyond and doing something voluntarily. Finally, and I say this admiring, this is Mr. Kemp at his best. Could you pull up the Brown deposition, please? I'm sorry, it's the white deposition, page 138. This is the head of recalls at UNFI, where he says, you made a conscious decision, didn't you? And he said, we made a conscious decision to put our assets where they do the most good. That, Your Honor, is not deliberate lack of a conscious deliberation. It's not despicable conduct with conscious disregard for the rights of others. That's consciously allocating resources where they will do the most good. It's exactly the opposite of what the standard for punitive damages requires. Then Mr. Kemp argues that the court should allow UNFW to be punished because its new policy is to audit everybody. Think about that. You have a subsequent remedial measure that voluntarily goes above and beyond and does exactly what the ideal is. And because you didn't do that before, we're going to punish you. It's crazy, it's absurd. Finally, on the causation, Your Honor, I'm not suggesting that Mr. Kemp can't go to the jury. I'm not suggesting that a jury couldn't possibly find causation related to the audit. They may very well do that. That might be evidence of negligence. That might be evidence of negligence per se. That, Your Honor, is not evidence of implied malice, which is a despicable conduct engaged in with a conscious disregard for the rights and safety of others, meaning the knowledge of probable harmful consequences of a wrongful act. There's simply nothing here. A failure to meet an industry standard might constitute negligence. It does not constitute evidence of implied malice and conscious disregard, and it certainly doesn't constitute clear and convincing evidence. I think there's only one right answer here, Your Honor, and that's to grant the motion for summary judgment on punities.
I just have one question for you, sir.
Yes.
When I'm looking at the 21 CFR section 117.
Yes, sir.
7 solely, what do I do with that?
What you do with that, Your Honor, is read the rest of the statute.
I have everything tabbed.
Yes,
I've
sir.
got copies of everything. I'm gonna read it all.
So,
But what is that? What do I do with it?
so this is a concept that's not immediately intuitive, Your Honor, but the Food, Drug, and Cosmetic Act imposes obligations on facilities, and it does in that sense as well. So it talks about what a warehouse is obligated to do. And UNFW, of course, purchases products. Every warehouse purchases products. They purchase some of the products they distribute. They purchase some of the products that they clean with or sanitize with. They purchase some of the products that they package and ship with. Solely means, just as Mr. Heidel asked, did you do anything to this product to reformulate it, repackage it, relabel it, reconstitute it? If I am taking a product that's intact and I am moving a product that's intact, that facility is solely engaged in the distribution of packaged unexposed goods. And that warehouse exemption applies, Your Honor, whether it's to a warehouse that buys a product or a warehouse that just has a product on consignment that's passing through. FedEx enjoys the exemption, UNFW enjoys the exemption, Nevada Beverage enjoys the exemption. Every supermarket on that list enjoys the exemption if they don't repackage, reformulate, relabel the product. If they do that, now they're a kitchen. And now they either have to have health inspectors or USDA inspectors or both. But if they're just moving sealed product, and that's why Mr. Heidel asked the questions he asked very specifically, then that exemption applies.
Right. And the reason why I asked that question, does it matter if, in this case, and I just want to make sure I get the acronym right, UNSI?
UNFI, or United Natural Foods.
Yeah. If they're buying it or they're purchasing the product, does that change their duties and or responsibilities conducting a purchasing function?
It does in this sense, Your Honor. We're here because we are strictly liable for any defective product that we sell that causes injury. So in that sense, the answer is yes. That's playing a strict liability hook on us. But that's the only sense in which our purchase of the product changes our duties or responsibilities. Otherwise, Your Honor, there's no difference between a shipper and an owner of a warehouse product. It does not do anything to change our responsibilities under the Food, Drug, and Cosmetic Act or under 21 CFR 117.
Right.
Thank you, Your Honor.
Thank you. I'll take a look at this. And I'll get you an answer Monday.
Excellent.
Monday morning. Anything else, Mr. Parker? You're looking inquisitively?
I just want to make sure we're not going to be here Monday.
No.
Just making sure you're on.
I'm not going to be here Monday. In fact, I'm looking forward to Monday not having to do I won't be in session. That's probably the best way to say it.
You were busy all week. I mean, I saw you Wednesday, I believe.
It's been, yeah, we were in trial, and we have, a motion. We're just busy for some reason. I can't tell you. But it is ebbs and flows. It just does. Sometimes you're really, really busy, sometimes not as much. And everyone enjoy your weekend.
You too.
Thank you.
Thank you.
All right.